Is it working? Yeah, very good. Good morning. Good morning to all of you physically sitting here at NUPI and to all of you following us online. And a warm welcome to this panel discussion on the theme of safeguarding the rule of law and democracy in Europe using financial means. My name is Christophe Illion. I'm a research professor here at NUPI and a professor of European law at the University of Oslo. And I have the privilege to moderate this morning's discussion, which is a very timely discussion. I have to mention that this event takes place in the context of an ongoing seminar series called Norway and the EU Towards 2030, which is a 3-year project that is led by the European Policy Section of the Ministry of Foreign Affairs with NUPI as an external partner. And the purpose of this project is essentially to provide expertise, to enhance competence, and to stimulate debate here in Norway, basically on key developments in the European Union which are of great significance for Norway too. The project covers 4 key areas, beginning with EU foreign security and defense policy, the EU's Green Deal. Third is the EU's work on health preparedness, and last but not least, democracy and the rule of law. And this is in this particular context that this discussion this morning is taking place. Our purpose this morning is to try and find out what can be done and what has been done and not done, particularly by the European Union itself, to tackle and possibly reverse a worrying deterioration of democracy and rule of law standards in some member state of the European Union. A development which was not necessarily expected, at least in principle, in EU circles. One can indeed hardly overstate how worrying and dangerous this deterioration is, not only for the EU itself, but more broadly for various mechanisms of cooperation in Europe, including with non-EU states. This development is therefore of interest, but also disquieting for non-EU countries like Norway, particularly given the depth of the relationship that Norway has with the European Union. So what we want to know this morning is how EU institutions have reacted to this worrying phenomenon. What means have EU institutions used in an attempt to restore compliance with EU standards of rule of law and democracy, and preserve more generally the mechanisms of cooperation that are so important for the peace and security in Europe. We're very, very fortunate indeed to have, I was about to say 2 leading, but I should say the 2 leading experts on these questions, Professor Kim Scheppele from Princeton University and Professor John Morijn from the University of Groningen, to enlighten us on these thorny issues. They will enlighten us in particular on the different mechanisms that the EU has crafted in order to address what has often been referred in the literature, but also in the press, as democratic and rule of law backsliding, with a particular focus on financial conditionality, which is of relevance not only in the EU context, but increasingly in the EEA context too. Let me just briefly introduce our 2 key speakers this morning, and then I will give the floor to each of them in turn. Professor Kim Scheppele is Lawrence Rockefeller Professor of Sociology and International Affairs at Princeton University. Her work focuses on the rise of autocratic legalism, first in Hungary and then in Poland within the European Union, as well as its spread around the world. She's held various full-time positions in very prestigious places, the University of Michigan, the University of Pennsylvania, and, importantly, at the Central European University in Budapest. You've also held various visiting faculty positions in law school in Yale, Harvard, Rotterdam, Erasmus Rotterdam, Humboldt, Berlin, And I have to mention that you have a book which is coming out fairly soon called Destroying Democracy by Law, which is forthcoming with Harvard University Press next year. John Morijn is Professor John Morijn is commissioner at the Dutch National Human Rights Institution, as well as a professor of law and politics in international relations at the University of Groningen in the Netherlands. And you're also a chair of the Rule of Law subgroup of the Mayors Committee, which is the standing committee of experts on international migration, refugee, and criminal law. The Mayors Committee is, for those who don't know, a Dutch NGO composed of judges, attorneys, scholars, and works on promoting compliance with EU and international law, transparency and democratic control. So it's a very important institution. I will stop by saying that this event is streamed, so it's available online, and that means also that you should be able to have another look at it later on when you feel like it. John will start with an introduction to the subject for about 15-20 minutes, and will be followed by Kim. We very much look forward to listening to you. John, the floor is yours. Pardon me. I should say that John and Kim have written a very insightful piece called What Price? Rule of Law, which is going to be published by the Swedish Institute of European Policy Studies in Stockholm, which is organizing a conference on the subject of the rule of law in the EU mid-April. So watch this space. John.
Thank you very much. I'm still blushing after this introduction, and it's lovely to be here in Oslo. I've also never been in a place where 2 or 3 minutes before the event everybody was already in their chair. So I feel the pressure. And so, who of you has ever been in the European Court of Justice? Have you ever visited? You have? That's how I wanted to start, because I want you all to close your eyes and think about the following scenario. There's a very large room, the biggest courtroom in Luxembourg, where the full court, so 25 judges are walking in slowly in their blue robes, one by one. Takes about 45 seconds, including the Advocate General who walks in. And then in front of these judges, there's an unusually large crowd. There's 3 institutions. There's representatives from the European Parliament and the European Council, the Council of Ministers, I should say. There's the Commission as a representative of the guardian of the treaties. And there's 12 different member states in front of these judges. There's 10 who are defending the rule of law that day, and a new instrument that I'll talk about later, the rule of law conditionality regulation. They are 5 of the 6 founding members of the European Union. They're the Netherlands, Belgium, Luxembourg, France and Germany. There's Finland, Denmark and Sweden. There's Ireland and Spain. And they are there because there's 2 member states in the European Union that have challenged the legality of this specific piece of legislation. And they are Hungary and Poland. And why do they challenge the legality? Because simply they have been outvoted in the European setting when this new piece of legislation, the rule of law conditionality regulation, was put in place, which is a qualified majority file. Thank you. The case happened on the 21st and 22nd of October in 2021. It was unusual because this wasn't even the only room that was occupied with that. I was myself that day in Luxembourg in what was called a salle d'audience, basically full of people who could only listen and saw the whole thing on the big screen. And one room down, there were about 30 or 40 journalists. I gave a lot of interviews that day, I can assure you. And they were all listening there to what I think was one of the most important hearings in recent history in Luxembourg, because it was really about what is the European Union about? What does it stand for? To what extent can you really enforce the founding principles of the rule of law in an EU setting, even in court. And specifically, and I'm going to talk about these instruments later on, but specifically in the case of the rule of law conditionality, what the Hungary and Poland challenged was actually 4 things. They said, you cannot enforce the rule of law in any other way than politically. There's already a political mechanism within the EU setting. It's a political dialogue called Article 7. Maybe some of you have heard of this. So one of the arguments by Hungary and Poland was that that is really the only and exclusive way to enforce the rule of law. You cannot do it in any other way. So that's the reason why this new conditionality regulation is illegal, because it basically sidesteps what should be the one go-to place to enforce the rule of law. The second argument were they were making that even if this rule of law conditionality regulation could be put in place, we're using the wrong legal basis. The legal basis for this was very boring accounting legal basis in the EU treaties. Sound financial management is basically when you spend EU money, you have to make sure that you get bang for your buck, or bang for your euro in our case. So it's a bit of a misnomer. It's basically a budgetary control instrument. The third argument that they were making is that the rule of law as it is now defined in this instrument is too vague, so we don't really know what we're enforcing. And the fourth argument was that because it's too vague, we also don't know how you would apply this forcefully. If you want to read about what happened that day in court, you can read a piece that I wrote for Verfassingsblog called A Closing of Ranks, because it was quite remarkable these 2 days to see the exchange and see that in fact there's a huge tension within the European Union, and perhaps at the moment we're having not one but 2 different European Unions clashing, and that you saw on display that day. Hungary and Poland lost big time on all 4 points that I just pointed out. You can read that in the judgments that came out a bit over a year ago, on the 16th of February 2022. So the court upheld the legality of the possibility to link rule of law compliance with cash. And I'm going to talk about this instrument, but also 2 other instruments to which the same possibility occurs. And I'm going to stress 2 things that may be sounding, I don't know whether many of you are lawyers here, that may sound really boring and grey, but are absolutely essential to understand the rationalities of these different instruments. That's the legal base. I worked for a long time in Brussels myself. Christophe didn't mention that. I was a diplomat for the Netherlands. The one question you always face is, what is the legal base? What's the rationality for the European Union to act here? You will see that there's actually different rationalities to link the rule of law to cash at the moment, and they're operational in a simultaneous way. And the second thing that's important is who is involved. Is it only the Commission who can act in a discretionary manner, or is there also sort of a political component that the member states themselves need to be involved and approve things? So I'm going to talk about 3 instruments, talk about them generally, how they work, what their rationality is. And then Kim will talk a little bit about how they're being applied at the moment to Hungary and Poland. And I'm going to talk about them in chronological order, how they've been published in the official journal of the European Union. They're Regulation 2020/2092, which is the rule of law conditionality regulation. The other one is 2021/241, which is about how COVID funding, EU COVID funding, is given out to EU member states. And then the last one is 2021/1060, which is probably the instrument with the least exciting name in the whole of EU legislation, but actually extremely important. It's called Common Provisions Regulation. I'm going to talk about to what extent that has something to do with linking cash to the rule of law. And then I'll make a little synthesis, and then Kim will take it from there. So the rule of law conditionality regulation was actually proposed by the previous commission, not the current one that is currently in place. And the way that EU legislation, as you know, works is that the Commission proposes something, and then it's for the co-legislators, the European Parliament and the Council of Ministers, to come to an agreement. And that's the reason why all three of them ended up in front of court when it was eventually challenged. And the legal basis here is Article 322 of the Treaty on the Functioning of the European Union, which is sound financial management. Sound financial management means nothing more than you have to make sure that the way that EU budget is spent and the financial interests of the European Union are protected is justifiable from the viewpoint of accountants. The line DG that is responsible for this in Brussels is actually DG Budget. So they are the finance people, not the rule of law people. But the rationality here was that there are some rule of law problems that are such a big threat to the way that you spend money that we have to make more explicit that if there are such rule of law problems in any of the member states, then this could be a basis for cutting funds or suspending funds. Suspending is actually important. It's not this is an important point. It's not a sanctioning mechanism. It's not that you can completely take away money that is due to member states. All you can do is suspend and make sure that you do not give money into any member states until the problem is solved. So it's a suspension. The money is still sort of reserved for that member state, and once the problem is solved, it can still go in. Now, it's important to explain a little bit what is the wording here and what is precisely the structure of this legal instrument. It says that if there's any sort of rule of law breach, and I'm going to define later on what a rule of law breach in the sense of this regulation means, that affects or seriously risks affecting sound financial management of the Union in a sufficiently direct way, that is a basis for the Commission to propose to the Council to cut funds. So let's go through each of these elements. There must be a rule of law breach that has an implication for the way that you can spend money, that is already there or is so evident that it risks having that effect. But it also has to the rule of law problem has to be linked to the way that you spend money in a sufficiently direct way. So it cannot be just any rule of law problem. It has to have a specific implication on the way that you're spending your budget. Now, of course, this would sound pretty vague, perhaps, and that's the reason why in 3 different steps the rule of law conditionality regulation actually defines what is the rule of law. It does so in Article 2. It then defines for the specific context of breaches that are relevant for the budget, what are the relevant rule of law breaches for the budget, and then in Article 4, paragraph 2, it says that there's a number of specific elements of the rule of law that are specifically harmful for the budget if they're under threat. And the best way to visualize this is as follows. Money from the EU that's reserved by the EU flowing into a member state can first run into problems of conflict of interest. So imagine corruption, basically. So imagine that you have EU money flowing into, let's say, the Netherlands. The Netherlands is then under an obligation to make sure that this money is divided or issued in a way that is the most competitive possible, and it is we have the best operator doing it for the best price. Now, if that is not the case, if there's conflicts of interest, if there's corruption, of course that's a threat to the budget. So that's the first kind of elements of the rule of law that are being defined here by the rule of law regulation. And then the second thing is that you can have a corruption problem or a conflict of interest problem, but that wouldn't be such a problem if you have an independent prosecutor who would then go after this crime, which is also a crime on the books in any of the member states, and also a European Union law-defined crime. The independent prosecution of misuse of funding is itself an element that is also specifically pointed out in the rule of law conditionality regulation. And then the third step is that if that then would end up in front of a court, these judges, of course, need to then be independent and impartial. So these are sort of the three steps, also the three stages that you would have when you have a problem with the budget that is linked to rule of law problems. So that's the way that this instrument is structured. How it can be triggered is as follows. The procedure is laid down in Article 6. Imagine that the Commission finds out that there is indeed a problem that is coming from a rule of law problem that indeed risks affecting the sound financial management in a sufficiently direct way. What it can do is send a letter to a member state that is suspected of these problems and get into a conversation about this. And this procedure is specific, and that is very important about this rule of law conditional regulation, because it has very short deadlines. So you have to have, you send a letter, and within 2 months, which is really short, it's much shorter than in the normal procedures. It says a little bit about how much we care about sound financial management in the EU setting. Within 2 months, a member state then has to reply and say, well, in fact, there are no problems here. If the Commission is not convinced, it can propose what are called appropriate measures that are proportionate. And appropriate measures are basically to what extent you have to cut specific funding that is specifically seriously affected by a rule of law problem. Kim, myself, and another professor called Dan Kellerman have written a report recently for the European Parliament, which you see here, freezing all EU funds to Hungary, where we're basically defining what would be proportionate, appropriate measures in some specific cases. So this is a legal issue. So the Commission then proposes something to the Council, which has to then agree on whether and to what extent it freezes specific funds. What is very important here, you need a qualified majority in favor of any proposal by the Commission in the Council. That's a very high hurdle. Recently this was triggered for the first time with regard to Hungary, and precisely why that was, Kim will explain later. But it's important to realize that this has now been triggered, and this has been put in place with regard to Hungary for 3 cohesion funds with and 55% of each of these cohesion funds, which amounts to about 8 billion that is currently suspended under this to Hungary. What can Hungary now do to unfreeze this situation? It needs to show that it has taken what are called appropriate measures to correct the situation with regard to the rule of law that Kim will explain. And then when it has shown to the Commission that it has indeed solved the problem, the Commission can go back to the Council and propose that, yes, we're convinced all of the 8 million can now flow, or no, we're only partly convinced, so we're only unblocking some of the things that are currently being blocked. So these are the 2 different scenarios that are conceivable. So what is characteristics about this, just to summarize on this particular instrument, it has to do with sound financial management. It's a budgetary control instrument, and the Council has a very important role. You need to clear a very high hurdle. Politically, qualified majority is a very high hurdle. And this was actually cleared, and there was no member state at all that was publicly against invoking this, which was remarkable given the fact that normally, for example, the Visegrad 4 member states support each other. And it was also remarkable because initially the Commission had signaled that it was planning to trigger this instrument not only with regard to Hungary but to another member state, Poland, but then dropped that halfway the procedure. So that's the first instrument, and that is the instrument that got all the attention. We have been talking about this at the European Council for 3 or 4 consecutive times. The higher you cannot get in the EU political setting. And this has led to 8 billion being eventually suspended with regard to Hungary. But I would argue that this is not the most important instrument. There's actually 2 that are more important. I'm going to talk about them next. The second is what is called the Recovery and Resilience Facility Regulation. And the legal basis for that is Article 175 of the Treaty on the Functioning of the European Union. And that is about coordination of economic policies. It's a completely different basis. It's very much a market-oriented legal basis. What is the background of this and precisely what is required, I'm going to explain to you now. So the background of this is very much, as you know, I'm from a country that is extremely stingy. The Dutch Prime Minister did not want at all to add 600 billion of EU monies to the budget. So when he realized that he had lost that political battle because Macron and Merkel had made the deal, he said, well, let's then at least attach conditions to under what condition you can get that money and what you should spend it on. And these conditions were found in something that had already previously existed called country-specific recommendations under the European semester. And this is really all about, and that's the reason why I'm stressing the legal base, it's all about making sure that the European economies are better integrated, that you reform the things that make your economy greener, more digital, and to make sure that it becomes as modern as possible economies. So basically what eventually the compromise was that, yes, we have this 600 billion extra over specifically to recover from the COVID and the damage that has done to our economies. But we only do this in a way that is linked to previously existing recommendations on how you can make your economy more competitive. Economic conditionality. Now, the reason why I'm talking about this here in the rule of law context is that in this completely different channel, some member state had received recommendations that actually were rule of law related under these economic considerations of the European semester. And they are the usual countries that we'll be talking about here this morning, Poland and Hungary. But the reason why the rule of law concerns came on the radar was not because they were directly a threat to the sound financial management or because rule of law in itself was sort of a problem for the European Union, but simply because they make your economy less competitive. That is the rationality here. Now, the way that this instrument works is that it says that when you want to have access to that money, and we're talking about 8 billion for Hungary and 36 for Poland, you need to submit to the Commission a proposal for a national recovery and resilience plan that need to somehow, in large part, deal with country-specific recommendations that you have been given by the Commission that have been cleared at the Council level. And these are called milestones, and they're put in milestones. For Poland, these milestones also consisted of some recommendations on judicial independence, but they only dealt with a disciplinary regime for judges. So in the meantime, this decision to conditionally give money to Poland if the disciplinary regime for judges is being reformed has been challenged by 4 umbrella organizations of European judges who basically say that by agreeing to these milestones, EU institutions, the Commission and the Council are basically undermining the case law of the Court of Justice that is much wider when it comes to judicial independence in Poland. It's not only about the disciplinary regime, but if I'm a judge in Poland at the moment, if I ask a preliminary question, I can be disciplined for the content of my question. That is now not at all considered in the milestones. So these 4 umbrella organizations of judges have now gone to the General Court to sue both the Council and the Commission for saying by agreeing to this, you're basically contributing to the violation of European Union law, and you're undermining the authority of the jurisprudence of the Court of Justice. we have some signs, and I'm saying we because I help these judicial organizations to bring that case as a member of what is called the good lobby professors, that the court takes this case very seriously, because the General Court has decided on its own motion to expedite this procedure, which is extremely rare. It only happened once before in the last 10 years, that on its own motion it decides to fast-track a case. Another example was the case that I started my talk with. It was also the own decision of the court to deal with it much quicker than you would normally have. And the questions that the court has now been asking sort of indicate that they're willing to really deal with the content of this case. So we don't really know whether the conditions that were attached to giving COVID money to Poland will be found legal at all by the European Court of Justice. And it seems that perhaps also as a result of this case, the conditions that have now been agreed with for Hungary, that were agreed with just a couple of months ago when it comes to giving EU COVID money, are much stricter as a reason, because the line of the number of milestones that Hungary has had to agree with to get access to that is much longer. The list is much longer. Kim will talk about that later. But importantly, they're also phrased as what were called super milestones in the press release by the European Commission. What they meant by that is that rather than in the case of Poland, that if you solve part of the problem, you already get part of the money. So if you solve one part of your rule of law problem, you already get some money. And if you solve another part, you get the rest of the money. In the case of Hungary, all of these things are front-loaded. That's why it's called a super milestone. So you first have to deal with all the rule of law problems before you get access to any COVID money. And here again, the legal basis is coordination of economic policies. So it's really about making our economies more competitive, and rule of law comes in only sideways. It's not the main concern. It's really about economic governance. Now, one of the reasons why, and I'm going now to the third and final instrument that I wanted to draw your attention to. One of the reasons why in 2018 the European Commission decided to propose a rule of law conditionality regulation was that it said that in some cases our existing instruments to control whether EU budget is spent in a good way are not sufficiently efficient and effective. So we need something extra. But what a lot of people didn't realize is that the existing instruments themselves, this excitingly called Common Provisions Regulation, was itself being updated as well in the same budgetary cycle. And one of the things that has now become immensely important is one of the articles in this Common Provision Regulation, which is Article 9, which reads very innocuously: Member States and the Commission shall ensure respect for fundamental rights and compliance with the Charter of Fundamental Rights in the implementation of the funds. So basically it says that you can only secure that you actually get the full funding if you do this in a way that is fully in line with the Charter of Fundamental Rights, which is itself part of the primary law of the European Union. Now, what is so interesting is that this now seems to be the basis for a lot of money being blocked, both to Hungary and Poland. Just before Christmas, on the 22nd of December, there was a press release by the European Commission that surprised even insiders like Kim and myself, who have been working on this for years. The headline was, Commission freezes 22 billion to Poland. And we didn't realize what that could be based on, and that's now the same with Hungary. And it seems to be that this specific basis in the Common Provision Regulation was actually the base for that, which is curious, as I said, because the whole reason why we started this whole negotiation on the rule of law conditionality regulation was that apparently the instrument that is now actually weaponized most was seen as not effective. So now, in fact, we have three instruments that are being applied simultaneously. Why am I stressing the importance of the Common Provision Regulation here? Because it's the way that it is used doesn't require any council approval. It's fully the discretion of the Commission to make a decision on whether or not the Charter of Fundamental Rights is here being complied with. So my reading of the tea leaves here is what the Commission did was use the political context of the rule of law conditionality regulation and only insisting on blocking just 3 funds for a small part to sort of make sure that there would be a qualified majority in the council to use that as a political backing for using the discretion that it has under plenty of other instruments in a more secure way. I think that's where we are now. But it's still curious that the same rule of law concerns, and this will be my last conclusion here, you see now that the same rule of law concerns in Hungary and Poland are being dealt with in 3 different ways under 3 different instruments with regard to Hungary and Poland, which is, to say the least, of course, highly confusing and also a little bit difficult to understand precisely what is the effect. Is it conceivable, for example, that if you solve a rule of law problem, that you still have a problem under one instrument and not the other? It's a bit unclear precisely what is the state of play there. So, as Christoph said, we just wrote the paper on this that will be soon available, so you can read the fine print here. But this is what I wanted to say about the 3 different ways that money is now being blocked. There are different legal bases, but none of them is really the legal basis that a rule of law warrior would really see as their natural starting point. This is all about economic governance. It's all about protecting the budget. And that's basically, I think, why this is so powerful, because we're talking with people from DG Budget, the accountants of the European Union, and not with the rule of law warriors who sit in a different building and have different instruments. So this is where I wanted to leave it and give the floor to you, Kim. Yeah.
Thank you very much.
Yeah. Great, so thank you, and it's wonderful to be here and to be with my distinguished colleagues. And it's true that John and I, along with our co-author Dan Kellerman, who's not with us today, have been working on this for years, and we were totally stunned that before Christmas, under cover of holiday, right? Everybody's on vacation, nobody's even noticing this is happening. There's this little story in Reuters about this little press release from the European Commission. And as we started to try to figure out what had just happened, I should actually repeat the bottom line numbers. So Hungary now has, we don't know for sure because we don't have all the documents, but something like $28 billion of European funds are being frozen to Hungary under these 3 different authorizations. Something like $110 billion are being frozen to Poland, even though I must say we don't have the documents. So the Hungarian ones have been dripping out. We can start to see what you look for, by the way, is you go to the Commission website and you look for implementing decisions on all of the different funding streams, of which there are such a confusing lot of them that, in fact, we have trouble knowing whether we've gotten them all. But then you find all the implementing decisions and you find whether they have conditions and you look at the legal small print. But basically what's just happened, in the last few months is that the Commission, and to some extent the Council, have, after more than 10 years of challenges, in which many of us, that you can just Google us on the blog, Verfassen's blog, and you will see that we have been for years saying there's a serious problem in the EU. The EU has got to deal with it because there really is no other authority that actually really could do something effective to bring our rogue member states of Hungary and Poland into line. And the Commission was, well, they would warn, they would express concern, they would go to meetings, they would say this was really a problem. And really, they were not doing nearly enough. We're saying the building's on fire, and they're saying, maybe we should have a fire department, And so it's been sort of more than 10 years of that. And that's why when finally, sort of in between the end of summer holidays and the Christmas holiday, all of a sudden all this stuff happened, and much of it happened really by surprise. So Those of you who have been following this will probably have seen that this so-called conditionality regulation that John described has had this long, tortuous path into existence. It was first proposed by the outgoing Juncker Commission when Frans Timmermans, who was really a rule of law warrior back from when he was foreign minister of the Netherlands, he really took the lead on this portfolio, and he tried really hard to push the Commission to doing something, primarily with regard to Poland, because I think by that time they'd given up on Hungary. And as that Commission was leaving office, and seeing that the next MFF, which is the Multi-Annual Financial Framework, which is the legal term for the EU budget, was starting this long process of negotiation, the outgoing Juncker Commission started trying to think about how can we attach conditions to the money. And so they proposed this regulation. The regulation had to go through this political process where it's approved by the Parliament, it's approved by the Council, and the Parliament would beef it up, and add more and more, power, and the Council would whittle it down, narrow it, and so on. And so this battle really went on for 2 years, and it finally passed in this irregular European Council meeting, famous European Council meeting, in December of 2020. I think Christoph takes the view that there was a meeting actually in July 2020 when all the documents pertaining to the European budget, and there's a package of them. There's the budget, there's this common provisions regulation, there was the conditionality regulation, and there was this recovery fund, which is the first time the EU has borrowed money on its own behalf or on behalf of its member states. All those regulations were going through as a package that was agreed in theory in July of 2020. And then in December 2020, it blew up. And it blew up because this conditionality regulation, as you've heard, was something that actually was passing through the ordinary legislative procedure because of the legal basis that it had. Okay, so those of you who know EU law know the procedure was given by which article of the treaty you attach a particular regulation to. And the fact that this was going through as a kind of financial regulation meant that all you needed was qualified majority when it got to the Council of Ministers. The budget, on the other hand, requires unanimity. So what happened in that famous 2020 December European Council meetings, remember European Council is the heads of state. They're not a lawmaking body. They're not supposed to be involved in lawmaking. They are the heads of state. They are advisory only. And yet this package of laws that were going to go into effect to implement the new budget blew up because Hungary and Poland suddenly realized they didn't have the votes to block the conditionality regulation, but they had the votes to block the budget. So they said, we're going to vote against the budget unless you cancel the conditionality regulation. Turns out, don't worry, actually, the EU is very well designed in the sense that if there had been no budget, it would have just gone on the past budget. So it doesn't, unlike the US where we shut down the government when that happens, the EU doesn't do that. So, so there was a backstop, but still, it generated this kind of crisis in the EU institutions. What do we do if these states that, I think by this time, most of the other member states had figured out that Poland and Hungary were, shall we say, not on an entirely pro-European, pro-rule of law path. And if there are all these files which require unanimity, then they're going to hold us over a barrel on every single issue if we start to crack down on them. And I think that kind of strengthened the spine of the Council. The immediate reaction, however, was that the spine kind of got a little bit weak. So the concluding comments of that European Council meeting caved in to Hungary and Poland in a certain way. They didn't back down. The conditionality regulation passed. So did the budget, so did the whole package. But in the concluding comments, suddenly the European Council, which is not a legislator, which cannot amend laws, actually, said, well, gee, maybe this regulation needs guidelines so that it will be properly applied. Not in the regulation. Not their job, actually, but they did it. And then they said, well, we know a couple of member states have problems with the legality of this regulation. So they basically instructed the Commission. I say this because this is actually not legal, right? This is like they're not supposed to do that. They instructed the Commission, don't actually enforce this until Hungary and Poland have a chance to go to the Court of Justice and find out if it's legal. Okay. First of all, the legality of this regulation was never in doubt because the regulation had been battered and beaten up and narrowed, and it had gotten so narrow that what started in the Timmermans, under the Timmermans guidance, as something more like a sanction, the way the original regulation went was that if a country has rule of law problems, you can withhold money because solidarity, various things. And as this thing went through the process, it became less, if you have rule of law problems, we will withhold money till you fix them, to being a regulation that says we have to protect the EU budget. And in the service of protecting the budget, we may need to withhold some money if it directly affects the way the budget is spent. So as the regulation went through, this connection between the good governance of the budget and the rule of law problems got tighter and tighter and tighter and tighter. So what came out at the end was functionally an anti-corruption regulation, because it was, for example, like suppose that Viktor Orban does something that I think he's actually wanted to do for some time. Practically speaking, he's done it for some time, and just shut down all the civil society organizations that give him trouble. By the way, thank you, Norway. You guys actually support the civil sector directly, which the EU doesn't do, and this has been incredibly important at keeping the civil sector going in Hungary. But suppose Orban wanted to shut it down. Does that affect the EU budget? No, because no money is being spent on civil sector organizations. So one of the things you see as that nexus got tighter and tighter was that it solved fewer and fewer of the problems that actually were being generated in Hungary and Poland with regard to the rule of law. And so I think, and this was unbeknownst to us because frankly those of us who have been working with the Commission, and John and I were working a bit with DG Budget as they were trying to figure out because DG Budget had not been involved in the conversations about what's going wrong in Hungary and Poland. And so, and they were, shall we say, not all that ambitious about looking very deeply to see where the problems were. What DG Budget identified as the problems were basically corruption only, and only with regard to Hungary. And they couldn't figure out how to use this regulation for Poland, because while Poland has, shall we say, a lot of rule of law problems, the government has basically been trying to control the judiciary, using pretty thuggish means and using means that are unconstitutional under Polish law. The reason why the Polish government gets away with it was that they illegally captured the Constitutional Tribunal, so there's no one to tell them it's unconstitutional under Polish law. But they've basically really changed the judiciary to the point where judges who were still independent fear that they will be hauled before a disciplinary tribunal if they try to enforce EU law or they make decisions contrary to what the government wants. And this rogue disciplinary chamber appointed entirely by judges who were appointed entirely by judges who were appointed by a judicial appointment authority that's been entirely captured by the government. This disciplinary chamber hangs over the whole judiciary and punishes any deviation from the party line. Okay, so that's pretty serious. The conditionality regulation, however, was not invoked for Poland because that didn't look like corruption in the spending of funds, right? In Hungary, you had a different problem. You had well-documented corruption problems. So there had been a variety of scandals. I mean, the big scandals like the prime minister's son-in-law got all these contracts to put LED lighting into a bunch of villages, and then it turns out the LED lighting was never installed, or if it was installed, it was broken. I mean, so it was, and then, so that stuff like that had been documented in Hungary. So it was clear there was garden variety corruption, right? The money was going to cronies. It was not being used to produce exactly what the projects had been designed to generate. And so that was why essentially the conditionality regulation got directed only at Hungary and only for anti-corruption measures. And what the conditionality requirement required was that Hungary put in place an anti-corruption infrastructure. So if you want the details, if you go to, John and I write on the Verfassens blog, so just look up both of us on Verfassens blog and you'll see way more detail than we can say here. But when the Hungarian government last fall tried to roll out its anti-corruption program, I was in hot pursuit. So I should say that one thing I used to do is I worked at the Hungarian Constitutional Court for 4 years in the 90s, and even though I am not Hungarian and I didn't grow up with this beautiful and crazy language, I had to learn it. So I have a weird specialization in Hungarian constitutional law. Okay, so as a result, I'm an enemy of the state, but I also track all their laws when they come out with them and try to explain them to non-Hungarians. So I went through line by line their whole sort of anti-corruption program. And basically what they did was they created a bunch of organizations that looked fine. They had, you know, the Integrity Authority, the Anti-Corruption Working Group. And so it had all the nice names and it looked quite beautiful. And then when you got into the guts of how the laws were written, Orban was able to appoint all of his cronies into all those positions, right? So looked fine, but it was full of friends. So we wrote about this. And fortunately, the Commission, I think, tracks our blogs. I mean, they know we're sort of annoyances also to the Commission at this stage because we're constantly telling them, you know, what are you doing about this, that, and the other thing? And so they paid attention to these blog posts, and they had to do an assessment, and they came out with an assessment that Hungary had passed the relevant laws, but that they were not, shall we say, working in practice. And so they went forward with the conditionality regulation recommendation that the funding be suspended until Hungary do something real. But the conditionality regulation, after all that work, because of the way it had been narrowed, because of the way it had been beaten up, because of the way that it really forced this connection between essentially corruption and the budget, there were a lot of rule of law problems that could not be dealt with under the conditionality regulation. So, you know, while the conditionality regulation was occupying most of our attention, these other two things kind of snuck in under the radar. You know, we didn't notice exactly how powerful these other instruments would be. You know, so one, as John told you, was the Recovery and Resilience Fund, the conditions that were placed on the money that came from this effort to borrow money on the markets and then use it. And the idea of the recovery fund was that it should be spent quickly to help countries recover from COVID by putting in place EU priorities and programs. And the conditionality there was the so-called country-specific recommendations. And that was really interesting because, like I said, John had mentioned, the country-specific recommendations are usually macroeconomic conditions that a government has to meet so that the European economy looks like one thing. But they had started adding, back in, I think it was 2017, to Hungary and Poland, also to some extent, I think Malta, Romania, Bulgaria, some rule of law conditionalities, meaning you can't really have a good economy if your courts are not functioning. Now, I learned about this first because I got a call from the European Central Bank saying, would you come talk to us about Hungary? I thought, well, that's weird, because I hadn't worked with the central bank. But the central bank was in charge of enforcing, or at least monitoring, the so-called country-specific recommendations from the European semester. Okay. All EU language, by the way, is incredibly maddening. They have facilities, semesters, you know, like who knows. But anyway, so there's this one kind of economic thing that the central bank was involved in. And as soon as judicial independence popped up on the central bank's radar screen, they suddenly realized they needed to talk to people about what was wrong with the courts in these countries. So that was the signal that the Commission was already putting into these microeconomic conditionalities, worries about how the courts were operating. And the central bank took notice. It alerted a different set of institutions in the EU and was put on track that when finally the European Union was going to borrow money and hand it out to countries, the country-specific recommendations could turn into conditionalities on the spending of funds. Now, here's what's interesting. Poland and Hungary, I should say, one thing to understand about Poland and Hungary is that both countries are run by lawyers. Viktor Orban's a lawyer, his whole inner circle are lawyers. Basically, the Fidesz party apparatus was invented while all these guys, and it's almost all guys, were in law school together, and they're all lawyers. But the same is true of the government of Poland. Mr. Kaczynski, he's just a backbencher as far as his official position is concerned, but he's the leader of this so-called Peace, Law, and Justice party. He has a PhD in law. The president, Mr. Duda, has a PhD in law. I think it's really interesting that in these two countries undermining the rule of law, they're doing it by law, right? Because a lot of this is weird laws that get passed through the parliament, aggressive interpretations of laws they already have. It's all the tricks that are in lawyers' books that we become both famous and infamous for, right? And so basically, as the European semester stuff was going through, what was interesting was that it did not appear on the radar screens of those two governments that this might close in on them. So when they were objecting to that package of laws that went through in December 2020, or that went through in the second half of 2020, neither Poland nor Hungary objected to that little phrase in the Recovery and Resilience Fund that said country-specific recommendations. Because it didn't, if it had said rule of law, they all would have gone ballistic, but it didn't. It said country-specific recommendations, get into the guts of this document, look at the very end of it and see what the list is, right? And so it snuck through without any objection. Okay. The same thing happened, and actually what became interesting was that that became the hook. So as the Recovery and Resilience Fund conditionality set in, the substance of what the Commission is requiring are actually fairly long. Well, Poland went through quickly and they did it badly. So by the time they got to Hungary, there now is a 3-page single-space list of things that Hungary has to do to fix its judiciary. Okay, so let me just say something about what happened to Hungary's judiciary, because I told you a little bit about Poland. So when Viktor Orban was elected in 2010, frankly, nobody thought he was going to be quite as dangerous as he has become. But he's a lawyer, and his group is lawyers. And while they had been out of government for 8 years, they had designed essentially a program for bringing every single institution, public institution in Hungary, under their direct political control. And they hired a bunch of private law firms in Hungary, paid for it with party money, and wrote, here's a little piece of a law, here's a piece of a law, here's a piece of a law. They were doing that over 8 years, so that when they came to power, and none of the law firms could see the whole picture, right? Because if you're only revising the civil code on this particular part, or you're only revising criminal procedure over here, you don't see the big picture. When the Hungarian government came to power, they started shoveling laws through the parliament at some astonishing rate. I mean, thousands of pages a week. The MPs didn't know what they were enacting. And a lot of it was jigsaw puzzle-like. So if you only saw this law by itself, you didn't realize it was going to hook up with some law from over here and create something that was very different than the impression you got from each one. So to some extent, this was all also being sprung on the larger Fidesz political party, who didn't understand exactly what was happening. And it's been interesting to see the defections from that party as they started to realize what had happened. But a lot of the attack was focused on the judiciary. And first they captured the Constitutional Court, although they did so legally, unlike in Poland. Then they tried to capture the ordinary courts by changing the system for appointing judges. Both in Hungary and in Poland, court presidents are extremely powerful. So if you have the court presidency, the court president is the one who assigns specific cases to specific judges. They don't have automated systems in these countries. So all you needed, so the Poles just went in and took a bulldozer to the whole thing, which made it very evident. What the Hungarians did was to first capture the court presidencies and then get enough judges on each court so that the court president, in assigning the cases, could always assure that any case the government cared about got to a friendly judge. That was much more subtle. The commission didn't know what to do about that, and I'm not sure they believed it till pretty late in the process. And every step was legal. So what do you complain about? So the commission had not brought a single infringement action against Hungary for violations of judicial independence since 2012, when one of the ways that Orban got to appoint all the court presidents was to lower the judicial retirement age from 70 to 62, lopping off the senior-most 10% of judges who were all the court presidents, because it's a seniority civil service system. Opened up all the jobs at the top, put their people in. The commission sprung into action, did an expedited infringement. They won the infringement. In the meantime, Orban's expediting firing all the judges, replacing them all. And at the end, when the commission won that case, the commission said, oh, well, what you have to do is give the judges you have more protection. And they were all the Orban judges by then, right? So it kind of backfired. So the commission had done nothing on this. But as it became evidently clear that the judiciary was rigged, suddenly the Recovery and Resilience Regulation, which also is trying to ensure the proper spending of funds, but it wasn't so linked to corruption the way the conditionality reg was, that was where all the conditionality went in on the judiciary. And there's now 3 pages of detailed things the Hungarian government has to do. They have laws, which I'm in the process of analyzing, to see if it's the same thing as the corruption program. It all looks nice, but by the time you work out how it works, it's not doing anything, which is kind of what I expect, but I'll work it out. So that's now what's going on there. And then finally, with regard to the Common Provisions Regulation, I don't, you know, when this is, it's a very boring piece of legislation, really. You don't want to read the whole thing. John has been through it. Also something called the Financial Regulation. I mean, the regulations about how you spend money in the EU are boring, technical, and, you know, only an accountant could love them. And so, but buried in there was this, suddenly, this conditionality on rights. Okay. So what does that capture? Well, that's actually captured a lot of other stuff. So first of all, the independence of the judiciary is, again, sorry for the EU speak, but is covered in part by Article 19.1 in particular of the Treaty on European Union, which says that every member state must maintain a system of effective remedies for the violation of EU law. But it's also covered in Article 47 of the Charter of Fundamental Rights, which grant fair trial rights to individuals who are pursuing their EU legal claims. So it's double dipping. It's both a structural provision in the EU treaties and a right. So once the Common Provisions Regulation said we can condition this stuff on rights, suddenly it also swoops in all the judicial stuff. So the judicial stuff, the judicial conditionalities from the recovery and resilience plans got copy-pasted into withholding money under the Common Provisions Regulation. But then, and like I said, we don't have it's interesting that the documents for Poland have not been published. You can ask us in questions why we think that's true. But the documents for Hungary largely have been, and that was where the Commission actually added in, so far as we can see, 2 other conditions. One is that Hungary's been having a decade-long fight with the Commission over asylum and migration, where Hungary has been found now in violation, I think 3 times, by the Court of Justice on different aspects of the EU asylum and migration rules. And frankly, the Hungarian government's refusing to comply with those decisions. So suddenly you see it's a CFR matter because it's a rights issue when the rights of asylum seekers are denied under European law, and so that's put in as a conditionality. We can't figure out how much money it's attached to, probably not much, but the non-compliance with the ECJ decisions is now in there on the CFR conditionality, and also there's a big battle going on between Hungary and the EU over LGBTIQ plus rights, and that got added in also. And, you know, I mean, they may be able to invoke more rights later, but the point is, by the time you add in all that stuff, it doesn't fix, I mean, this will not fix all the reasons why Hungary is no longer a democracy, but it will fix a number of things, I mean, and more than we thought they could fix. With regard to Poland, it seems to be mostly focused on the judiciary, which frankly is really where most of the problems are. And so now what we've got out of both of these processes is a list of things the countries have to do. And so the big question, excuse me, going into the future is, will the Commission, having made this dramatic intervention, will they actually hold the line and not give the money out until the problems have actually been solved, or at least made less problematic? Or will they be satisfied with cosmetic legal reform that, when you get down to the ground, doesn't change much? And this is where I'll just conclude by coming back to where I started, which is, when you're dealing with Hungary and Poland, you're dealing with lawyers. This is a good thing and a bad thing, right? So the good thing is that they understand all the legal stuff, and the EU, how to put, law is the common language of the EU, basically. And so they speak dialects of the same language. The problem is that when you get lawyers like the ones in Hungary and Poland, they're also expert at making law look good while being bad, right? It's a technical thing that lawyers can do if you don't watch them. And so I'm reminded of something that happened in my own country. As you now know, we're all on indictment watch against our immediate past president. But the last president who ran into legal trouble was Richard Nixon. And there's a guy called John Dean, who was Nixon's White House counsel, who was one of the key witnesses against Nixon at the time he resigned from office. And he has a wonderful article called what was Watergate? And in that article, he pointed out that out of the 28 people who went to jail for the Watergate break-in and cover-up and all the crimes that surrounded Nixon's resignation from office, of the 28 people who went to jail for Watergate, 25 were lawyers. And so this is the territory we're on. Lawyers have the immense possibility of convincing themselves that something that is legal is also the right thing to do. And this is why it's really important that non-lawyers, who don't tend to confuse those things, also monitor what's happening. So I hope everybody who's a non-lawyer will also feel invited to participate in the process. Thank you.
Kim, John, thank you so much for these two tour de force, these illuminating presentations, both on the various financial tools that the EU has crafted over the years and how useful they have become to react and to try and push back what are indeed very, very worrying, if not extremely dangerous situations on the ground. Also, thank you for, not only today, but generally for keeping us up to date with these developments on the ground and putting the different bits together to show how deep the deterioration of democracy and the rule of law has gone in several member states of the EU, and indeed for doing all this tedious, boring job of putting these things together also at the legal level. John, thank you so much for shedding light on this very technical, dry, boring pieces of EU legislation which could be so usefully weaponized to try and protect the rule of law and democracy in the EU and more broadly in Europe. And thank you also very much to both of you for reminding us of how dangerous lawyers can be. On that note, I will immediately open the discussion to all of you. We have quite a bit of time, if we need it, to have an exchange. We got a lot of thought-provoking points, so I hope you will not hesitate to intervene. Please introduce yourself when you take the floor. And be as concise as possible so as to allow as much discussion as possible. So I can see Łukasz, Pernilla. Łukasz, please. The microphone, yeah, there will be a microphone circulating.
Thank you very much. My name is Łukasz Bojarski, and I'm a lawyer by education.
And you have the best T-shirt. I love that one.
That's why I put it today, of course.
Thank you. It says Constitution in Polish, and it emphasizes me and you.
Yes, you and me.
Yeah.
So it's a graphic that became a symbol of resistance. So I have 2 points, and the third one very short to make. First, I wanted to thank you very much, all 3 of you actually. You are just moderating, but you are all 3. You are what I consider friends of Poland. Even you've learned Hungarian, not Polish, but you know, after learning Hungarian, Polish should be like a task for the weekend. And even Christopher once proposed in one of his entries in the Verfassung blog to maybe the bad guy should leave the club when writing about Hungary and Poland, and that really provoked an interesting discussion. But you are all 3 friends of Poland, and I'm a Polish citizen, so I would like to thank you in my name, the name of my children, for all your activities, for your academic writings, but also for your involvement in advocacy. This is what I really appreciate, because as we know, there's a discussion about, you know, role of science and its objectivity, impartiality, etc., etc. And I really admire the fact that you are involved in kind of advocacy, kind of public debate, not just isolated academic writings. And you, John, for example, you also educate the future generations of lawyers, and you run this beautiful project that I just wanted to say. It's called Our Rule of Law, isn't it? And one of your students came to University of Oslo, actually, Anna Walczak, and she was a star, I can tell you. So thank you for this. And now on the substance. I'm waiting for this book on lawyers destroying democracy by law. But I hope that you will include a chapter in this book on lawyers saving the democracy as well. And not just academia, not just academic lawyers, but also judges that you have mentioned. Because what I'm doing, I'm finalizing some writings right now on judicial resistance of Polish judges vis-a-vis those authoritarian measures.
Łukasz, can you bring the microphone a bit closer to you?
Yeah. Yes, of course.
Thank you.
About the judicial resistance of Polish judges against those authoritarian measures. And this is exactly what I wanted to ask you. The story has started in 2010 with Hungary, yeah? So it's, as you said, over 10 years. For many years you were, not just you, but many people were appealing to the European Commission, European Union institutions, or of course not just them, to do something, yes? Nothing has happened. As we know, you were very critical, and this club of good lobby professors was very critical about it. But something has changed, and my first question to you is, what is your general evaluation right now when it comes to the effectiveness of the EU measures limiting the rule of law backsliding, to quote you? So are you really satisfied with those financial mechanisms? Because this is strong, of course, billions. But what is your general evaluation, and what would you still suggest? What kind of measures to accompany those financial measures? And second question is, I'm formulating an argument that the role of Polish judges in all this story is very important. That the movement that started in Poland of two groups, civil society together with judges, which is quite unique on this scale, has influenced many things. But of course, you sociologists, it might be easier for you, but it's of course very difficult to via research to prove that something on this scale in such an international institution happened because of somebody's action. There are so many factors here, so many people, so many institutions, so many factors. But honestly speaking, and I'm asking you, yes, because my impression is that the Polish judges, by formulating the preliminary questions, which in fact was a strategic litigation because it was all strategized together with the civil society. It was not just a judge asking the question from the court, as you know. Yes, it was more of the impact litigation, and also the Polish lawyers, like Free Courts Initiative, etc., etc. You know, meeting with Timmermans that started this. What is your evaluation of the input of the Polish civil society organizations and Polish resisting judges into bringing this issue, rule of law decline, on the agenda much more seriously, and hopefully resulting, I mean, we know already that there are very many positive results when it comes to the verdicts of the Court of Justice, later European Court, which is slightly different, but also kind of strategic litigation, and those financial mechanisms. Thank you.
Thank you, Łukasz. Do you want that we take just a couple of questions, or do you want to react straight away?
You're the chair, you can decide.
Yeah, up to you.
I suggest we take 3 questions and then give you some time to think about your answers. Pernille, please.
Thank you so much, and thank you for very interesting and engaging presentations. I'm not a lawyer, so I will have more kind of broad.
Good for you.
We need lawyers on the good side too, right? I didn't mean to exclude lawyers.
Yeah, sure, but it's
just
more
to say.
Yeah, absolutely. I know that, but so my question would be maybe more kind of overarching, because I think there are 2 questions that I'm wondering about, and it's not that technical, but it's more. As you say, the EU has done quite a lot recently, and some surprising decisions in kind of the past year. So I wonder if you could say a little bit more what more can be done kind of to improve the situation? So that's the first question. I don't know if it's a simple question, but it's an overarching question. And the other thing is a bit to focus a little bit on Norway as well, because one thing is what the EU can do, but what can Norway do through the EEA grants that we have, and and there is also kind of some conditionality mechanism that we can use. And as you said, that these grants have been focused also on the civil society, but there are some challenges with that when there are no civil society to support. So what can be done, what can Norway do to support the EU in this process and to contribute to solve this kind of rule of law and democracy crisis? Thank you.
Thank you, Pernille. Last question, I think. We have a non-lawyer over there from NUPI.
Yes, so I'm just a simple economist from NUPI. But it was good to hear that there are still fields in these days of statecraft where money speak. But anyway, I found your presentations really interesting, and I made an attempt to study the new EU budget. And I read some of these recovery and resilience plans and recommendations for some countries. And my question was then, how binding are they? Are they kind of best endeavors things? How much do they bind? So then it was very interesting to hear that you had so specific recommendations in the legal field linked to these RRF procedures. So yeah, so that is one question: how binding and how and what makes them, what creates the implementation of these RRF plans. The second question is about the discretionary power of the EU Commission, the European Commission, because in all these three fields, I think the Commission has power. So, but what are the limits and what are the checks in these three fields about the Commission powers?
Thanks, Anna. I suggest we stop here with the questions. We'll come back to questions later on, but to give the opportunity
just a few
to
small
speakers.
topics.
Very small, simple, short questions. Yes. Yeah. Kim, would you like to start? Or
no, I mean, I don't feel free to speak as a lawyer. It should Kim who should start.
I didn't mean to. But look, everyone on this platform works through law as our main medium of focus, right? So we hope that they're good lawyers too, right? But it's just the problem when you're dealing with bad lawyers is that they disguise their tracks better than just ordinary bad people. So it's harder to fight them. That's the only point I wanted to make about lawyers, really. Yeah.
Kim,
should I start, or do you want to start?
I can start if you like. Lucas asked, and that's a very important question. Out of nowhere, we now have 3 financial instruments that are applied simultaneously. So we're going from 0 to 100. You asked about the effectiveness of that measure. I have to say I'm still thinking about that. And what I have in mind specifically is how this affects normal Polish and normal Hungarian fellow EU citizens on the street. Because they're the ones who are the prime victim here, right? So I think that the main danger of taking this route, that is really the money talks route, as was summarized there, is that you will lose what is most precious in these 2 countries, namely the legitimacy and the credibility of the European Union on the street, simply with the normal citizens. So I think it's a very high stakes game that you're playing. So it could never replace the real hard work of simply convincing fellow EU citizens of the intrinsic justness of having separation of powers and the intrinsic judgments, the intrinsic value of the necessity of a judge being independent even if you disagree with him. And I think that hard work the European Commission and the EU institutions have been pretty poor at. And what I worry about is that now that we let the money talk, that we forget about the importance of doing that work. You asked about the effectiveness of the input by judges and NGOs, specifically from Poland, Lucas. last week, you mentioned already, I organized a conference called Our Rule of Law Academy, which was about students learning about the rule of law from 25 different member states in Brussels. And one of the most interesting speakers we had was somebody in the cabinet of one of the commissioners. And one of the students asked, it was all for students, by students, one of the students asked this person, what convinced you for the first time that there was a problem? And that was when they actually met a judge, Igor Tuleya. Because if you understand that that this is not an abstract problem, but there's a man here who is just taking his job.
Movie describing the story.
Yeah, exactly. Yeah, no, I mean, I found it. So they have been very effective in convincing simply by the strategy that they have, just being very principled, but also calm and doing very good media work. So I'd be looking forward to your book. As to Pernilla's question, what more can be done? I think it's actually what more can be done is that you actually do the hard work of convincing on the content, not only by withholding funds. What I find very interesting, a few years ago I ran a project called Vote for Values, which was basically about trying to explain if you vote for European Parliament elections in the Netherlands for a completely mainstream party, that you also vote for cooperation with that mainstream politician with some populist in another country. Mainstream parties in the Netherlands work together with politicians who basically undermine the rule of law elsewhere in Europe. I think that that is also hard work that needs to be made much clearer. For example, for the next European Parliament elections. The most funny story, I think I already told Kim once, I wrote an op-ed in a Dutch newspaper basically saying that as a Dutch voter for the European Parliament elections, whatever you vote for, you can only vote green to make sure that you don't indirectly vote for populists at the EU level. I got a phone call from a very upset person from a headquarter from a very mainstream political party. How could I dare to associate their political party with populists at the EU level as well? I think that rather than demanding a corrigendum from me, maybe you should just ask your own member of European Parliament to report why this person is working with law and justice in European Parliament. So there's a huge information gap, and that is a gap that needs to be filled and that needs to be taken up. You asked what can Norway do? Basically, what I would say is just continue the good job. It's important to. Norway was the very first one who was actually, it was light years ahead of being principled in Hungary, for example. And I think that was part of the reason what convinced people in Brussels, Houston, we have a problem. And I think that hopefully because of the leverage that you have financially, but also in terms of the credibility that you have on the principles, that could be continued. Then the gentleman in the back asked 2 questions about the limits and the possibilities, the discretionary power of the Commission. Part of the reason why I have a sort of a dim view on the sustainability of having a very principled position, for example, on COVID money, is the following scenario. Imagine that Spain does not fully comply with this economic conditionality, or Italy doesn't comply. And they put pressure on the Commission, and it's very unlikely that that will not become political at the European Council level very quickly. So I think that in some way the countries that are now being targeted under this conditionality are sort of the soft targets that have little political clout at the European Council. But if this had been about an economic conditionality with regard to one of the much bigger member states, I think that the Commission would be on a much shorter leash. On the other hand, it is a very clearly worded economic conditionality in this RRF regulation, and it is actually what countries have agreed to themselves, right? They are putting this plan forward to get access to this enormous amount of money. So in that sense, it's not only within the application of it is within the discretionary power and the assessment of the Commission, but eventually it was cleared by the Council and agreed to by the Member State itself. So you can also just hold up a mirror to these member states and say, well, we're just holding to what you promised yourself?
Yeah. So first of all, these are great questions. And let me just say something about Polish civil society. So the fact that people went to the streets to defend the courts was just immensely important. I mean, it was important both because you saw that there was a huge public support for rule of law, democracy, constitutionalism, and so forth. The Hungarians kind of gave up. And they didn't give up because they don't care. They gave up because this plan that Orban put in place hit every single institution in the first 3 years. And plus he had a constitutional majority. And so everything was legal. That put off people saying, well, gee, if it's legal, then what's wrong with it? You know, so that's why, the reason why I made that point about lawyers was not to put down any lawyers in the room, just to enlist you all in this defense of like legal principles, but to say that one of the effects of doing things legally is to convince people that there's nothing they can do because it's legal. They have the majority. They've done all the procedures properly, and it kind of disables a certain kind of critical judgment in the public. In Poland, because the government just did things illegally from day one, and it was really evident. And what they did was illegal, not in a technical sense only, but just visibly illegal, right? You didn't have to be a lawyer to understand that what they did wasn't legal. And the fact that people went to the streets was really important, and I think the effect that had at EU level, this is something I hear all the time in Brussels institutions, they worry about who they're going to work with if this government falls. And in Hungary, it's a real question because Orban has so systematically disabled the opposition that it is unclear who would govern Hungary if Orban fell. There's no logical successor. All the opposition parties are, I mean, some are very sincere and people I really like a lot, but they have no experience. They're not unified. They don't have enough people. They don't have a plan. And so the EU gets very nervous about pushing too hard on a country if it doesn't think there's an opposition there that can pick up the slack. So it matters a lot that there are people in the streets, that there's opposition parties. I mean, even if they can't win elections, the EU needs to see, for it to do its job, that there's somebody who can govern if this government falls. And that's been a big difference between Hungary and Poland at commission level. On activism, so there is this debate going on that John and I have been, skewered in a bit, of there are European lawyers who say, you should stick to European law and not do all this activism. And what I always say is, what I'm saying now used to be obvious, right? Rule of law, constitutionalism, it all kind of matters, checks and balances. Like, since when did that become activism? It wasn't me that made that decision, right? If this is controversial, and if it looks like a stance in a political fight, this is what, people who work on constitutional law, like I've worked on for many years, this was just considered normal professional conduct, right? So it's the context that's made us activists. And I think that what I'm concerned about with many of my academic colleagues is that they get so freaked out by the fact that the normal science of their discipline is now a pole in a political argument, that they're tempted to give up the normal science of their discipline. And this goes all the way from like the people who are working on COVID prevention all the way through to people who work on con law, right? So there's this general assault on expertise. And unless we defend the things that made our disciplines worthy of public trust, we just have to, right? And I don't think of that as activism. All right, so thank you for letting me do my soapbox speech on that. On the what can be done. So one of the problems, so on one hand, I think John and I and others who have followed this issue really closely are amazed that the Commission did so much so quickly. So first of all, I don't think it was that quick. By the time you go back and you trace all the little landmines they stuck in the laws that they could explode at a given moment, it's been going on for at least 4 years that they were sort of building up these tools. And the fact that they've now suspended, again, the numbers, more than 110 billion euro to Poland and almost 30 million euro to Hungary. And the difference in the amounts is not the difference in severity. It's how much they were going to get to begin with. Poland's just a lot bigger, so it gets a lot more money. But this is all the cohesion funds. It's all of the funds that are part of what are called the partnership agreements between the member states and the EU, which include a lot of other small funds. It's all the recovery monies So what's going? The only funds still going to the member states, so far as we can see, are the agricultural funds, which are really substantial. And frankly, I think the reason why the agricultural funds were not targeted in this round was because each of these different regulations is being enforced by a different Directorate General of the EU with a different commissioner in charge. The commissioner in charge of agriculture is the Polish commissioner. I think they just decided we're not going to touch that because they couldn't figure out how to do it. And putting never mind about the assignments of commissioners to portfolios, it wasn't a good idea. So they're not doing that. So there's a lot of stuff that, so these funds being cut are enormous. You look at the conditionalities, and here's the concern that I have. Judicial independence is absolutely crucial to everything, so I'm glad they started with that. Anti-corruption in Hungary is crucial. I'm glad they started with that. Even if they fixed all those things, there would still be serious problems in both countries because these measures don't reach a lot of important stuff. So in Hungary, the elections have been rigged since the election laws passed in 2012. The opposition cannot win an election. If you want all the evidence for that, there's a journal called the Journal of Democracy. I published an article last July called How Orban Wins. And you will see all the election tricks. There is no way the opposition can win. None of these conditionalities address that. And in general, the kind of democracy problem, because also in Poland, you have this dilemma of the opposition getting its act together and mounting an effective challenge to the PiS government. Both the Orban government and the PiS government in Poland are actually genuinely supported by a lot of people. And even if you were to change the governments, there would still be, this is so different from the transitions of 1989-90. I mean, they were very rough for everybody that went through them, but the communists walked away. The Soviet Union walked away. Everybody was in favor of democratic change. If and when we ever change the governments in these two countries, the people who were against democracy and the rule of law are still going to be at the table with a lot of their supporters insisting on participation in what happens next. They're not going to walk away. So this transition will not look like 89-90 if we can get there. So what's actually being requested now in these conditionalities are absolutely crucial and central things that have to change, but it will not be enough to fix the problem. And then the question is, what do we do then? So actually, Christoph is working on some really exciting stuff in this regard about there is a requirement in the treaties that says, participation of member state governments in European institutions, sitting at the council, sending a commissioner, relies on the member states themselves being representative democracies. So how are we going to weaponize that one, right? Like we started with rule of law, which was the judicial bit. Now a number of us are looking at this. But what Christoph is doing now, can I explain this, is looking at, and this is where Norway comes in.
But
No, well, this is where Norway comes in,
yeah.
Is that there are a lot of treaties that the EU as an entity has signed with third states that rely on what is in EU speak mutual trust, which is to say enforcement of legal judgments. The treaties require that the treaty partners enforce the legal judgments of all the member state courts in the EU. And if the EU can't get it together to ensure that the member state courts are not just under the political thumb of the local dictator, the international treaties start to fall apart, right? So this is Christoph's project, so watch this space. I think this is genius as an argument, because if the EU won't clean up its own house, then Norway can do it for it. Okay, so that brings me to the what can Norway do. So Norway, it was true, in 2013-14, the Norway funds, which actually included both the EEA streams and the specific, it's complicated, but all the money that Norway was giving to Hungary, particularly for the civil sector, Orban tried to hijack that money, because the way the program works is that Norway gives money to not to the member state, but the member state and Norway agree on an NGO that will get the money and run the grants competitions and distribute it. And Orban wanted that NGO to be one of his, we call them in the US, AstroTurf organizations. Do you know this expression? AstroTurf is fake grass. It's that stuff they put down to make it look nice, but there's no actual roots. So if you think of grassroots groups as having real groups, AstroTurf looks like grass but has no grassroots. Okay, so these groups that are formed by the government but meant to look like civil sector organizations. So one of those was the one that Orban insisted that all the Norway money go to. and Norway, to its incredible credit, because you guys were the first to really challenge this, said, we're not giving money to that group. We will wait until we get an independent one. And this fight went on for years. Frankly, the EU was like, we're not paying attention to what's going right. They didn't do anything. But you guys were the first to call it out. So this is my first trip to Norway. I am like so proud of you guys for doing that, because in Hungary it made a huge difference. So just keep doing that, please. And then just finally on the last, if I can.
2 words, because we're running out of time.
Oh, sorry. So just on the last question. So the Commission, there are checks on this. The Commission has a ton of discretion. There are checks, one of which are lawsuits. So there's a lawsuit going on now. One thing we didn't mention is that in Hungary, most of the public universities, which are most of the universities, have now been privatized. The government created, the literal translation of the long Hungarian word is public interest asset management foundations. They're private law foundations. The government just donated universities, the buildings, the land, the libraries, the people, into these private foundations. In the course of that, all the faculty lost tenure, by the way. And the boards of these private foundations are ministers, state secretaries, MPs, and friends of the governing party. And by moving the universities into the private foundations, there's no audit trail for public funds because they're not public funds anymore. There's no Freedom of Information Act requests because they're not public entities, et cetera. A lot of what was meant to be covered in the Recovery and Resilience Fund, there are the special conditions, a lot of it was research and development, and a lot of that money was going to go to universities. So in the RFF recovery plan, the Commission said, and no money is going to go to these private universities because we can't tell whether it's being properly used. They made that up. Now, they made that up based on some research we had done and published, and they were right to do it, but it kind of came out of thin air as far as the Hungarian government was concerned. So now one of the Hungarian universities is suing the Commission and Council, right, because it's the implementing decision they're challenging, to annul the act that says you can't give money to Hungarian universities. And that's how the Commission's discretion is checked, right? And we'll see what the Court of Justice says about that. So the one okay, that's it. But anyway, so there is check. It's called lawsuits.
Thank you so much. It's my mistake. I thought we had until 12, and I've just been reminded that we had until 11:30 only. But it just shows that there's so much left to be explored. And the good news is that there's a lot of research being done on democracy and the rule of law in Oslo, at NUPI, and also at the university. I'm turning to my colleague here, Daniel Naurin, a director at Arena. We have another research project on enforcement of the rule of law in the EU. So watch this space. There's more that is coming both at NUPI and in other circles here in Oslo. And I'm sure I can count on my 2 colleagues and friends to come back to Oslo whenever we need it. Thank you so much to both of you for taking the trouble to come all the way, and I insist on that, to Oslo from the United States, from the Netherlands, to illuminate us on this worrying trends in Europe, which deserve to be studied, but which deserve to be engaged with in order to push back this really worrying, contain and definitely reversed. And also for engaging us and making sure that we do not remain in these ivory towers of ours, but engage in practice, because this is important stuff. So thank you so much again, and a round of applause is needed.